Welcome to the deep dive. Today we're really getting into one of the thorniest problems in contract law. We tend to assume that if you breach a contract, you lose everything you put into it. But what happens if the party who defaults, the one who actually walks away, has already made a huge payment? Can that party, the one in breach, really get their money back?
That is the exact legal knot we're here to untangle. This whole deep dive is about that conflict, that tension between two completely different legal ideas. We're going to be contrasting the really strict old common law forfeiture rule with the much more modern approach you see in the Restatement of Contracts, specifically Section 374.
Right. And our goal for you, the listener, is to do more than just understand this shift. We want you to master the precise step-by-step method you need to apply this modern rule. We're going to model a really rigorous element-by-element breakdown of a case that turned this whole area of law on its head. So let's start with that baseline, the history. Before all these modern reforms, what was the traditional common law rule for a breaching party who wanted their partial payments back?
Well, the traditional rule was absolute. They called it the forfeiture rule, and it was brutally simple. The breaching party was completely 100% barred from recovering any payments they'd made before they defaulted.
So you breach, you forfeit, that's it.
That's it, full stop. And for a long time, that was the dominant rule in almost every jurisdiction.
What was the thinking behind a rule that's so punitive? If contract law is mostly about compensation, why would the common law insist on a total forfeiture that often feels more like a penalty?
The rationale was mainly moralistic. It was all about deterrence. You see scholars like Corbin and Perillo talk about this. The idea was that a party who breaches should never be allowed to, have advantage from his own wrong intimately. In that view, allowing a breacher to get their money back was seen as inviting contract breaking. It just lowers the stakes for walking away from a promise.
But wait a minute. If the goal of contract law isn't to punish people, but to make the injured party whole, doesn't taking all the money, even if it's way more than the actual damage, kind of undermine that? Isn't that what the critics argued?
Precisely. That is the core weakness of the old rule. It often leads to what lawyers call unjust enrichment for the non-breaching party. The law really dislikes it when one party gets a massive windfall, a benefit that's way beyond their actual provable loss. And it got really unfair when the breacher had, say, almost finished their performance.
I see.
As Corbin famously pointed out, the injured party gets to keep more money the more the other party did before they defaulted. So the rule, which was meant to deter a breach, ended up just being a really harsh penalty.
So the common law was basically saying, you broke the contract, so you have to pay the full price no matter how cheap it is to actually fix the problem.
Yeah.
That's the tension the modern rule tried to fix.
It did. And so courts started to adopt a fairer standard, one that focused on compensation, not punishment. And that standard is the Restatement, Second of Contracts, Section 374.
Okay, Section 374. Can you break down the elements of that for us? How does it actually set up a right to recovery for the person who defaulted?
So we're looking mostly at Section 374, subsection 1. It sets up the breacher's right to get money back based on a crucial two-part test. First, the party in breach has a right to restitution for any benefit they've conferred, like a down payment. That just establishes that the money was paid. Second, and this is the really critical part, the recovery is strictly limited. It's only for the amount that is in excess of the loss that the breach actually caused the other party.
That sounds much fairer. The seller keeps enough to cover their actual provable damages, and anything left over goes back. But what's to stop a clever seller from just writing a penalty clause into the contract? Something that says, if you breach, I keep all your payments no matter what my actual loss is. Doesn't that just create a loophole to bring back the old forfeiture rule?
That's an excellent question, and it's exactly why subsection 2 of 374 exists. This is the limitation that stops people from using the contract to get around the rule. Recovery is barred to the extent that the amount the seller keeps is reasonable, as what we call liquidated damages.
For our listeners, can you just give a quick, accessible definition of liquidated damages?
Sure. Think of it as a pre-agreed estimate of damages. It's written right into the contract before any breach even happens. It basically says, if party A breaches, we agree party B's loss will be X dollars. End quote. But the key legal word here is reasonable. If that amount is totally out of whack with the actual or even the anticipated loss, if it's really just there to scare someone into performing a court, we'll call it an unenforceable penalty. The seller can only keep the payment if it's a reasonable stand-in for a loss that would be hard to prove in court.
This is where it gets really interesting. How did a court actually use this modern rule to overturn its own state's precedent? Let's analyze Lancellotti v. Thomas. First, what are the legally dispositive facts?
All right, so this case involves the sale of a business. The appellant, Lancellotti, agreed to buy the appellee's luncheonette for $25,000 cash. That's the benefit. The deal also included a 5-year lease, and that lease required Lancellotti to build a 16 by 16-foot addition to the building. This was supposed to cost about $15,000. Lancellotti pays the 25 grand and starts running the business, but he defaults on the construction. He claimed he couldn't get a permit. The sellers, the Thomas family, took the business back and ended up building a bigger addition themselves for about $11,000. Then Lancellotti, the buyer who breached the contract, sued to get his $25,000 back.
And what was the core legal issue that the court had to resolve?
The precise question was whether a defaulting buyer, who's already made these big payments, is just completely barred from getting any of it back under the state's old forfeiture law, or if they might be entitled to restitution under these newer, more modern restatement principles.
What rule of law did the court end up applying? Could you state the full rule and break it down into its testable elements for us?
The court made a big move. It explicitly rejected the state's existing common law and instead applied Restatement Section 374, subsection 1. And the elements of that test are designed to force an accounting, not a forfeiture. The elements are: 1, did the breaching party confer a benefit through part performance? And 2, is that benefit in excess of the loss that the breach caused the injured party?
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply that first element, benefit conferred?
Well, the analysis for that first part was pretty quick. The $25,000 cash payment was, it was undeniably a tangible benefit that Lancellotti conferred. So that element was met right away. The court pointed out that the buyer paid this money hoping to complete the deal, and the seller got it. The real issue wasn't whether a benefit existed, it was whether the old law would ever let him get it back.
Understood. The payment is clear. Now, what about the second element, the excess of loss caused by the breach? This is the math that decides who gets what. How did the court handle this calculation?
This is where the trial court got it wrong, and the higher court stepped in. The trial court just used the old forfeiture rule. It basically said, Lancellotti breached, so Thomas keeps the 25 grand. End of story. But the Superior Court said that was a legal error. They failed to do the required calculation under the modern rule. So the step they ordered for the remand, sending it back to the lower court, was to determine the sellers, the Thomases' actual quantifiable losses from the breach. And these losses could include a few things: lost rent, the $11,000 it cost them to build the addition themselves, the value of any missing equipment. And the key is, the buyer only gets back the part of the $25,000 that's in excess of the total of those proven losses.
So the trial court's job is to do the math. $25,000 minus the seller's total proven loss. And that equals what the buyer gets back. If the seller's loss was, say, $15,000, the buyer gets $10,000 back.
Precisely. You move from an automatic punitive forfeiture to a compensation-based accounting. It's a huge difference.
And after analyzing all these elements and finding that the trial court used the wrong legal standard, what was the court's final conclusion?
The Superior Court decisively adopted Section 374 for Pennsylvania law. They rejected the old common law rule, calling it an unjust forfeiture, so they remanded the case, sent it back down. And the holding is a clear command. The trial court must calculate the seller's actual provable damages. And if those damages are less than $25,000, the buyer, Lancellotti, is entitled to get the difference back. That 25 grand is now basically a security deposit against actual damages, not an automatic penalty.
That breakdown is so important. To really make this stick for the listener, let's use a more visceral example. Imagine a buyer pays $100,000 up front for a custom industrial machine. They breach when it's 99% complete, but the seller can just turn around and sell that almost finished machine to someone else for $95,000. Under the old forfeiture rule, the buyer loses the whole 100 grand. What happens under Section 374?
Oh, the difference is night and day. Under Section 374, the seller has a duty to mitigate their damages. So the benefit conferred by the buyer is $100,000. But since the seller can resell the machine for $95,000, their actual loss from the breach is only $5,000, the difference. So we apply the restatement calculation. $100,000 benefit minus the $5,000 loss equals $95,000 in restitution. The buyer is entitled to get $95,000 back. This example shows the entire purpose of the rule. It's to avoid that massive $95,000 windfall for the seller that the old common law rule would have allowed. The key is that the buyer has to pay for the loss they cause, but they don't lose everything.
That makes the principle perfectly clear. Now, you mentioned that adopting this rule in Lancellotti was a pretty big deal because it went against established state law. What was the dissent's main argument? Why did they think the majority went too far?
The dissent, written by Judge Tamilia, had a really powerful argument based on judicial hierarchy. They argued the majority was basically doing the state Supreme Court's job for them. They said the court was applying a law, the restatement, that was, and I'm quoting here, so new as to be virtually unknown in Pennsylvania precedent. They pointed to other cases, like Loria v. Robbins, that still follow the old common law forfeiture rule.
So the dissent wasn't necessarily saying restitution is a bad idea, but that this specific court, an intermediate appellate court, didn't have the authority to just change what was essentially Supreme Court precedent on its own.
Exactly. Restatements are incredibly persuasive, but they aren't binding law until a state's highest court says they are. The Lancellotti court took a bold step here, adopting this equitable rule before the Supreme Court did, which is what makes it such a landmark case for contract reform in that state.
This has been a really technical but absolutely necessary deep dive. So what does this all mean for you, the listener? If you come across a situation like this, on an exam or in practice, how should you structure your analysis to make sure you hit every element and avoid that old forfeiture trap? Can you give us the actionable checklist?
Absolutely. The main thing is to immediately stop thinking that breach equals total forfeiture. You have to think like an accountant trying to prevent unjust enrichment. So here is your essential 5-step checklist. 1, issue spotting. Has a party breached but also conferred a benefit they want back? If yes, you immediately state restatement section 374, subsections 1 and 2 as the governing law. 2, quantify the benefit. Figure out the exact dollar value of what the breaching party gave the other party, in our case, the $25,000 payment. 3, calculate actual loss. This is the key. You have to precisely calculate the non-breaching party's actual provable damages from the breach. Remember, they have a duty to mitigate those damages. No vague penalties. 4, calculate the restitution. You just subtract the actual loss from step 3 from the benefit conferred from step 2. That difference is the maximum amount the breaching party can get back. And finally, 5, check the limitation. This is the subsection 2 test. If the contract had a clause about keeping the payment, you have to test if it's acting as reasonable liquidated damages. If it's really an unreasonable penalty just to scare people, that clause is unenforceable, and you go right back to your calculation in step 4.
That framework really clarifies the shift. We're moving from a system of sort of moralistic punishment to one based purely on actual measurable compensation. The rules are there to make the injured party whole, not to give them a bonus because the other side messed up.
That's it, exactly. The core policy here is that the breacher has to pay for the damage they caused, but that's the ceiling.
And that leaves us with a final provocative thought for you to consider. If a contract explicitly says that a retained deposit is not for damages, but is just a penalty for breaching, should a court use Section 374 to strike it down? Or should it be allowed to stand if the amount seems reasonable? That is the subtle but vital distinction between damages and penalties that defines so much of contract drafting.